discarded, what he did to search for deleted records, what records he has in drop boxes, which are in the cloud, and I'm sure there is one in this situation. And no one has given me any evidence that, yes, we have complied with the open records request. And the reality is, at least as to some of the contractors, they basically said, we did nothing for a month and a half and got paid. Okay, that's at least an answer to this court that they don't have any records because they didn't do anything. They got paid by the taxpayers, but they didn't do anything. All right, I accept that. There's this other subcontractor that we still don't know whether they were a subcontractor or was this at a different period of time after August 30th, and that would then be taken up in Judge Remington's case. But we don't have anything from the Office of Special Counsel, before it was the Office of Special Counsel, that is sufficient in this court's mind that says we followed the open records law and did what we did. And we know that they deleted documents. We know that some documents haven't been produced. And so I'm skeptical. Perhaps there aren't any documents. That's one answer, that this went on for 4 months. The Office of Special Counsel received a great deal of money and didn't do anything. Or there are documents, and if these documents do support what the Office of Special Counsel is attempting to do, then I think the people in the state deserve to see that. If they don't support it, the people in the state deserve to see that too. So,
can I just be heard on that, Your Honor?
1 second. It's not like this is Batman, that you have to send out the bat signal to get somebody to respond. This is a contractor that is in Waukesha with an office in Waukesha where you live and work, and someone could have gone over, sat down with him and went through, okay, did you do this? What's your procedure? Did you delete documents? Did you not delete documents? Do you have anything saved on the cloud that's responsive? And someone could provide an affidavit that says that they did this. You don't need a bat phone for that. I mean, it's not like you don't know where the Office of the Special Counsel is. And in fact, the last hearing we had in this case, or the other case, all I said is, don't destroy records. And I think the response was, well, we have no control over the Office of Special Counsel. That's just not acceptable to the court.
That is practical reality, though, Your Honor. And let me explain. So it isn't as simple as Commissioner Gordon turning on the bat light and summoning Batman. Somebody has to see it and somebody has to respond to it. I don't have control over Mr. Gableman. And we talk about the Office of Special Counsel, but remember, what we're dealing with here is really Mr. Gableman. It's a contract with his LLC, which he is the president of. It's not an actual contract with the Office of Special Counsel. And what we're talking about is a period of time that predated the Office of Special Counsel. I don't control Mr. Gableman. I don't have the authority, and nobody in the state has the authority to walk into his office and demand that he sit for an inquisition, a deposition, anything like that. I can't go to his office and search his computers. I can't search his desk. O'Connor versus Ortega, 480 U.S. 709. The Fourth Amendment applies to government and government employees, and I can't go and search a governmental employee's office, his desk, or his file cabinet. And if I can't do that with a governmental employee, I certainly can't do that with a contractor. City of Ontario versus Quam, 560 U.S. 746. Supreme Court said text messages on somebody's pager that has been provided by the governmental employer cannot be searched without a warrant because it would violate the Fourth Amendment. I can't go and search Mr. Gableman's phone or get his text messages. Riley versus California, 573 U.S. 373 from 2014. You need a warrant to search the contents of somebody's cell phone. I can't go search Mr. Gableman's cell phone. We just litigated a case in front of Judge Peterson in the federal court, Bowers versus County of Taylor. It's reported at 2022 U.S. District Court Lexus 68959. The decision issued April 14th of 2022, where he said that employees have a reasonable expectation of privacy in password-protected accounts. It was a Dropbox account. And the court said, password-protected Dropbox account, you can't go and search that without warrant. I can't go and search Mr. Gableman. The court can issue an order. I can't. And we have done everything within our power to try and find every document that's out there. So we sent that action plan to Mr. Gableman last November, asking him to search, giving him all the particulars of what it was that had been requested. In April, we sent that to his counsel and said, please direct Mr. Gableman to do that. And he worked with the clerk, Zachary, to do that. One of the things about a purge condition is it's got to be something that's within my power to control. So we've gone to the other contractors, asked them to look for everything, gotten them to tell us, I don't have anything else, I did very little, I didn't text, I sent any emails I had, they've been produced already. We have done all of that. We talk about deleted emails. We did, in the other case, produce 20-some thousand emails that had been deleted during this period of time. And those would also show to us if there had been some communications from Mr. Gableman to anyone within Mr. Voss's office to Mr. Gableman, or if someone from Mr. Voss's office was carbon copied on an email to some other person. And some of those showed up in the search. They're innocuous. There's nothing really critical, but it's docket entries 156, 157, 159, 162, 166, 170, 173. Those have been produced. We have no other documents in this matter, and I've exhausted my ability to get any documents from anywhere else. On behalf of the legislature and on behalf of Mr. Voss, I have done all that I can to comply with the court's order, and I don't have any ability to do more.
But I don't understand. What you're telling me is Mr. Voss hired a contractor who should be under his control and direction, and he's just run amok and is flatly refusing to follow any of the court's guidance or orders that subject Mr. Voss to liability. I mean, that's what you're telling me, is that Mr. Voss, who has the control and responsibility for this contractor, can't get his own contractor, even though he has a contract with him, to do or cooperate with him to just satisfy the court that they've turned over all the records that they have. That leads me to think that they're hiding something, or they don't want to tell this court that they've turned over all the records because they haven't. And that's something that perhaps Speaker Voss needs to address, that his own people are running amok. But
let me just make sure that we're all clear on something. Mr. Voss does not have a contract with Mr. Gableman. The legislature has a contract with Mr. Gableman.
Which makes it even worse.
But I've gone back to that contract, and I thought, surely there must be something in this contract that would let me say, I have some authority to compel something here. The court has a copy of the contract. It's a fairly bare-bones contract. I don't think people anticipated an issue like this in a contract with a governmental contractor. I think in the future people will. But there's nothing within the contract that gives me that ability either.
May I be heard? Thank you, Your Honor. The open records law provides the relevant authority here, which says that records of a contractor have to be provided to the same extent as if they were maintained by the authority. So I don't know what else the contract needed to say. I agree with the court that there is a surprising lack of curiosity on the part of Mr. Voss, who is the contact for the assembly on this contract, about what the contractors did to search, who the contractors even are, who are the subcontractors. We submitted the document signed by Mr. Kloster from August 1st. Do you think that would have at least prompted an inquiry about who all of these people were working at this time? The respondents, despite the court's explicit instruction not to, still seemed to delegate almost every aspect of the search to Mr. Gableman. They provided the same memo as last time, from November to April, and got the same result, which shouldn't be shocking, but also it's shocking to me that they tried to do the same thing because it generated the same result, which is no more records than the 27 documents we have from last fall, even though also documents that American Oversight is getting from other sources keep trickling in and indicating to us that the production is incomplete. One of them we filed with the court right before the last hearing. It's docket 132, the letter to Arizona Senate President Karen Fann from Mr. Gableman dated August 1st of 2021. American Oversight didn't get this from anybody in Wisconsin. It was received through Arizona records requests. It should have been produced. And it also disproves this notion that things really weren't getting started up in the investigation until late August. That's, again, from August 1st. So there should be records. And we also agree with the court that the respondents have provided no information from their lead contractor, Mr. Gableman. Again, we get the very short declaration from Mr. Zachary. I think it's Nemirowitz. That's what I'm going to say anyway.
Thank you.
And other information from other contractors is spotty or absent, again, like this Mr. Kloster one. So going on the outgoing end from Mr. Voss, we have no indication that they provided search terms, directions, details about the search. What search terms did you use? What accounts did you search? Which email accounts did you search? Were the drop boxes searched? Were there any hard copy files? Any of that information you would expect that to have been provided, and that I think we even flagged in our first motion for contempt that this is the kind of information you would expect, and we still don't have it. The respondents' filings about how they search their own records, that's just off topic. It's an opposite. We're here searching for contractors' records, not things that Voss had in his own files, and that's the subject of a different case. And we don't have any information about deleted records from contractors. And that's a big problem because we know the Office of Special Counsel and their contractors think that they can delete documents in some circumstances. So we're frustrated as well. The respondents have not purged their contempt. They haven't even acquired the basic information necessary to do so still. Again, such as information about who are the contractors, who are the subcontractors, are there volunteers, other people who would have been performing this work last summer whose records would have been responsive.
What about this argument that somehow the Fourth Amendment prevents them from asking their own contractor for the record?
I've never heard that kind of argument made in an open records case before. I don't understand why we're even talking about that. Certainly, Mr. Voss has the ability to go back to Mr. Gableman and to his contractors and ask these basic questions about that would enable Mr. Voss to comply with his duties under the open records law.
And to be clear, Judge, I'm not saying we can't ask, and we have asked.
You're just not getting any answers from your own clients.
Not my clients either.
Right, your own client's contractor.
And I can't force the issue. I don't have the ability to just go there and say, I'm going through your file cabinet, I'm going through your phone, I'm going through your computer. I can't do that.
I don't think, Your Honor, we have evidence that they have asked, honestly. All we have is a document saying, here's the request, provide us what you have.
And we should ask, but there's no affidavit from you saying, I did ask him all these things, and he's flatly off said, pound sand, excuse my language. But that's the impression I'm getting is you've gotten finally the other contractors to admit that they didn't do anything and got paid to do nothing, but that could explain why they weren't on board for very long. And then you say, well, we need to ask Gableman's office, but there's no link with, did you, here are the questions that I think that need to be asked and need to be answered. What are the names of all the persons who provided services in your capacity under the agreement you signed with the Assembly during the period covered by the record request? So that would be from when this started. What was it, March, May?
No, it's June 1.
June 1.
Right, almost a year ago.
June 1 to August 30th, right? That's
right.
All right. Then there was, where did you store either physically or digitally records that might be responsive? What attempts did you take to search those locations for the responsive records produced by each of the persons who provided you with services? What devices and accounts were searched? What search terms did you use? What attempts did you take to find out if any responsive records have been destroyed? Have any responsive records been destroyed? Describe them. What attempts did you take to recover deleted, lost, missing, or otherwise unavailable records created by contractors? And are there any additional records that fit in the time frame from June 1st to August 30th? I think there are. In some of the other cases, I think there's been some indication that there's records that would relate to this time frame. Not that I have been looking, not that I really think that that's the court's obligation, but I'm really skeptical when I can't get an answer from the person who has the answers, who has a very easy way to resolve these purge conditions. And I now am somewhat sympathetic if it is the case that Speaker Voss and the Assembly is between a rock and a hard place, but they hired this person. This is their contractor. And if he's gone rogue and refuses to do what they ask of him, then I think they have some other remedies that maybe they need to look into. But it just astounds me that you hire somebody. I'm not saying you search their stuff, but basic discovery when you're a lawyer is you sit down with the people and you say, have you done this? Do you have any places? Or are there any filing cabinets that you might look? You don't actually have to search these yourselves, but you certainly need to talk with him. And frankly, at this point, and as a practicing lawyer, I would search. You got these documents here. Let me have them. Let's take a look at them. Because that's the only way to get the end of this. If I had gotten an affidavit that said, this is what I've done, I don't have any more records, then I think we can draw the conclusions that there were no records generated because nothing was done. Or if they have records, why not turn them over so the people of the state can decide for themselves whether there's anything here or not? This is all cloak and daggers. And this isn't Batman because you know who this person is. He doesn't have an alternate identity that's hidden in the shadows. I think the open records law was designed to bring sunshine into state government for everyone. So I want an affidavit from you saying that you discussed all these things. If Mr. Gableman refuses to provide an affidavit, then I hate to say it, I'm going to continue and start assessing contempt. Right now, I'm going to defer. I'm going to let you another shot at purging the contempt because I don't want to hold Speaker Voss and the Assembly in contempt just to have the taxpayers pay more money for something that should be easily resolved. So I'm going to give you one last crack at purging your contempt. And that's getting an affidavit from Mr. Gableman. Or I'm going to start assessing monetary fines.
Your Honor, may I also request that we get an affidavit from Mr. Voss because the people he has employed he has delegated his responsibility to sort this out clearly have not done the job. I think Mr. Fawcett would be one of those. But we also agree that we need to hear from Mr. Gableman. Would the court agree that if we have a specified set of questions, we think it would be appropriate to ask Mr. Gableman, or for Mr. Voss to ask Mr. Gableman, we can submit those to counsel or to the court for the court to review? I think we've all talked about the same things essentially so far. What did they search? Where did they search? Which accounts? Those kinds of details. Who did they search?
All right, provide those to the court and opposing counsel. How long do you think? And it should be basic. I don't want these, we don't have to get into the weeds, but I do have, like I said, the information that I'm looking for is where are these records stored, what attempts were searched, what search terms did you use, who are these contractors, has any documents been destroyed, why, and is there any way to recover missing or other available records? And that was my understanding in the other matter, some documents were printed out and then electronic ones were destroyed. That makes no sense to me. But, so I want an affidavit from Mr. Gableman. I'll give you when you can get those list of questions.
I think we could turn that around pretty soon, maybe early next week.
Okay, and I'll allow you two to meet and confer, and if there's any issues with the breath or the questions, you can bring it to the court's attention, and I have some time to address it. And then June 16th is a drop-dead date.
June 16th?
Yep. And we might as well put this back on my calendar in case there's any additional issues. $3 o'clock on June 16th, would that work?
That works for me, Your Honor.
That's fine, Your Honor.
Okay.
Will this be an evidentiary hearing? Do Mr. Voss and Mr. Gableman need to be here? It might be the simplest way to just get these answers.
I don't know. Does the court have the jurisdiction to subpoena Mr. Gableman?
I could discuss my client subpoenaing Mr. Gableman for the hearing.
Okay. Because that's something that I'm not going to. All right.
Can I just be clear on something, Judge? Ms. Westerberg asked about submitting these questions, and she started mentioning Mr. Voss's name, and then she switched to Mr. Gableman, but now she's mentioned Mr. Voss's name again. My understanding is these are questions to Mr. Gableman.
Right.
Thank you.
I think Mr. Voss he sat for a deposition. I don't know how much more he can provide at this point.
Yeah, and in the deposition, we didn't ask him questions about this case, but I think that ultimately the buck stops with him, and the authority comes from him as the person who signed the contract on behalf of the assembly to get these records from the assembly's contractor.
I understand, and that's why if they are produced, he'll be the one in the contempt. And I understand that, and I think that it puts him in a bad position if it truly is that his contractor is refusing to take guidance from the person who employed him.
And just so the record is clear, my position continues to be Mr. Voss does not have a contract.
Right.
Is not the authority who has a contract with Mr. Gableman. And we have asserted all along, he has no liability for Mr. Gableman. It is the legislature that has that responsibility. I just want to be clear.
I understand. He is the speaker. Yeah. Now let's move right along.
Judge, may I ask one other housekeeping question?
Sure.
Sorry to interrupt. The agreement between the parties, or the scheduling order that we vacated earlier, said that we would discuss a date to submit our fee petition at some point in the future. Should we just defer that until after June 16th at this point?
Yes, please.
Thank you.
All right. 21 CV 2521, American Oversight versus Robin Voss. We're here on the motion hearing. First of all, there's a motion to request that Aaron Dummas be withdrawn. Does anybody object to it?
That would be in 2440, the case we were just in, Your Honor.
Oh,
Yep, he was withdrawn in 2521 already, and then we still need 2440. So we resubmitted the order this morning for that, so let us know if we need to do anything else.
no, I'll sign it.
I don't care which case it's in, I have no objections.
Okay.
Thank you.
So, all right. So now, you want to speak, so, yeah, let me call it. It's 21 CV 2521, American Oversight versus Robin Voss. May I have the appearance for the plaintiff?
Plaintiff American Oversight appears by Krista Westerberg of Pine Spach, as well as Sarah Colombo with American Oversight.
All right. And for the respondent?
Thank you, Your Honor. Attorney Ron Stadler of Kopka Pincus Dolan appears on behalf of Speaker Voss.
Okay. Now, this motion was to keep these records confidential, the deleted records that were turned over. I just want to understand, now these deleted records that were turned over were a product of certain search terms, correct?
Correct.
All right. And has anyone has your client gone through these deleted records to determine whether any of them are in fact subject to certain privileges or otherwise should be kept confidential?
In regard to privilege, we provided the court with a privilege log. So anything that we asserted was privileged has been separately called out, and we filed that privilege log with the court. The motion itself was simply that these are not records from Mr. Voss's office. These are records from the file servers of the Legislative Technology Services Bureau, which is required to keep those records confidential. And that's the basis of the motion is these are not public records within the meaning of 19.32. These are the product of discovery. And because the LTSB records should be maintained confidentially, we had filed the request asking that they not be shared. To some extent, the horse is out of the barn. American Oversight dropped all of them on their, I don't know if it's all of them, I speak in hyperbole occasionally. They put a whole bunch of them on their website.
Well, you want to speak to that?
Yes. So I don't think we need to get to the substantive issue about the LTSB and whether they need to be maintained confidentially. We've said in our response brief that the answer to that is no, emphatically no. We agree the horse is out of the barn, and to that extent, we're not even sure why this motion is still pending and why the defendant hasn't withdrawn it. And the defendant, the horse is out of the barn because of their own conduct. The defendant itself made these records public through the court's docket since April 7th, before it filed this motion. In docket number 122, Exhibit A, it's a document filed by Mr. Stadler, which contains a link to all of the records that anyone with a web browser could access. And we pointed this out in our response to their motion to restrict access over a month ago on April 12th. And as of at least last night when I checked, the link is still live. So if defendant were concerned about restricting access, this link would be dead, but it's not. So it's incredible to us that they're asking the plaintiff to do something that it hasn't done, the defendant hasn't done. And so the court should deny the motion to restrict our use of the documents under those circumstances. I will agree, American Oversight has posted most of these documents online. We indicated we would in our response filing. They are the public's records from public servers, so that was appropriate. And we've also used some in our summary judgment filings. So events, I think, have overtaken the motion, some caused by the defendant itself, and it would take a lot of unnecessary work to walk it all back.
Let me just cut it short, Judge. Because they let the horse out of the barn, I think it is impossible to walk it back. I don't think the court needs to waste its time with the motion anymore.
All right, I'm denying it as moot, so I also believe, though, American Oversight and the respondent himself, they have all published these records for anybody to receive, so I'm denying the order as moot. And that's it. I think that's it for today.
Thank you, Your Honor.
Thank you. Going to adjourn the hearing.